Welcome to Medmarc's webinar series. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. Today's presentation is titled Claims 2025, Navigating an Increasingly Difficult and Complex World. On behalf of Medmarc and today's presenters, thank you for joining us. Andy Hall is an executive claims specialist with Medmarc. He joined Medmarc in 2017 and is responsible for claims investigation, coverage analysis, managing reserves, negotiating settlements, monitoring defense counsel activities, and maintaining good client relations. He is also a critical member of Medmarc's product development team, where he assists with drafting language for our new products. Andy began his career as an associate at Wilson Elser, where he was later named of counsel. He specialized in drafting coverage opinions and interpreting insurance policies. Andy graduated from Wake Forest University with a BA in Political Science and History and attained his JD from the University of Pittsburgh School of Law. Also joining us today is Ricky Benjamin. Ricky leads the FDA and life sciences industry practice at Burr Forman. Ricky advises companies on FDA regulatory, compliance, and enforcement issues, as well as clinical trials and FDA-regulated product development programs. He also counsels clients on the safety, labeling, and reporting requirements for consumer products under the laws enforced by the U.S. Consumer Product Safety Commission, unfair and deceptive trade practices involving the Federal Trade Commission, and related state enforcement agencies. Ricky's clients include pharmaceutical, medical device, biologic, dietary supplement, cosmetic, and personal care products manufacturers, clinical laboratories, and compounding pharmacies. Ricky also has extensive litigation experience in the areas of medical malpractice defense, qui tam litigation, mass tort, product liability, and risk management counseling involving the Foreign Corrupt Practices Act, the Federal Food, Drug, and Cosmetic Act, and the Federal Tort Claims Act, as well as involving the Federal Trade Commission, the Department of Justice, and the Office of Inspector General, and the Centers for Medicare and Medicaid Services. Ricky holds a Bachelor of Science in Computer Science from Southern University A&M and received his JD from the University of Iowa College of Law. And with that, I am pleased to turn things over to Andy Hall, who will begin today's presentation.
Thanks, Kate. Just going to go through the slides here real quick to get us to our agenda. I'm excited about our agenda here today. We have 5 main topics, and we're going to start off with Ricky here in a second. And I want to, again, extend my thanks to Ricky for working with me on this. I think we have a good blend of litigation, regulatory, and maybe just some of the general craziness that exists in this world today. So we'll start off with the admissibility of 510K evidence. I'll talk to you all about GLP-1s and Loper Bright. Ricky will talk to you about recent developments with LDTs. And then I will end our core discussion here with some slides on autism and Tylenol. So with that, let me move it over to our first topic for Ricky, admissibility of 510K evidence.
Thank you, Andy. I'd like to talk to you about the admissibility of 510K evidence against the backdrop of many defense lawyers punting on preemption and not exercising use of 510K evidence, and plaintiffs' lawyers being more aggressive in arguing the inadmissibility of 510K evidence and the lack of applicability of expressed and or implied preemption. But before I get into that, I'd like to start with a little regulatory background that animates the discussion on 510K admissibility. In 1976, the medical device amendments categorized medical devices based on risk: class 1, class 2, class 3. A class 3 device requires pre-market approval and provides the FDA with reasonable assurance that the device is safe and effective for its intended purpose. And that's going to be key as we talk about preemption and 510K evidence admissibilities. Class 1 and 2 devices are subject to less regulatory scrutiny than class 3 devices, and they are cleared for marketing if they are found substantially equivalent to a predicate device that is approved by the FDA via the 510K process. I always encourage defense counsel to consider using 510K evidence to make preemption arguments as part of their initial defense strategy, because if successful, defendants can take an early significant bite out of the plaintiff's case. There are two types of preemptions, express preemption and implied preemption. With express preemption, they are created by statute and based on the device's intended use. With implied preemption, they are preempted and determined based on case law. Now let's talk about the myth. Preemption arguments utilizing 510K evidence have been discouraged by the safety myths, and let's get into that. The consistency with which plaintiffs argue that safety is not applicable in 510K cases arises out of the Medtronic versus Lohr case, and this case has been consistently cited to defeat preemption arguments. They argue that 510K process is focused on equivalence and not safety, and therefore safety has nothing to do with the 510K process. Therefore, a product safety and compliance with 510K evidence is essentially irrelevant. But defense attorneys should push back on this myth. Equivalency and safety are not mutually exclusive. Equivalence is used to establish a baseline and or floor, meaning that an equivalent device is as safe and as effective as the predicate device. Otherwise, the FDA would not clear the device. Once the FDA clears the device, it is saying that the device is as safe and effective as something that's already on the market. And that requirement cannot be overstated. So what's the recommendation to manufacturers and the strategic approach? Make a case for safety. The FDA, in recent opinions by the Supreme Court, simultaneously maintains the exhaustive pre-market approval process and the more abbreviated 510K process, both in order to ensure that medical devices are reasonably safe and effective. If the agency has found that a device is substantially equivalent to a predicate device, then the agency is saying the device is as safe and as effective as a legally marketed device already in commerce. Let's go through the preemption test. The medical device amendments, next slide, Andy. The medical device amendments preempt state law when the federal government has established specific requirements applicable to the device. With respect to the 510K process, those specific requirements are found in the special controls that are applicable to 510K. With respect to those special controls, that establishes that the device is as safe and effective as a predicate device. So what's the approach strategically for defense counsel? Defense counsel should take a tiered approach through preemption and or admissibility. One, argue that the 510K requirement expressly preempts a plaintiff's claim entirely. That's the big hit, that's the big win, and that's what you should go for first, because you're arguing that it is expressly preempted through the special controls. Absent express preemption, the argument should be 510K requirements at least impliedly preempt plaintiff's claims. And if that isn't successful, then fall back on admissibility, which proves reasonableness of a manufacturer's conduct. At least 510K evidence is admissible to prove the absence of a design defect or the absence of negligence. And that is the tiered approach through which defense counsel should go through 510K. In some recent cases, Cook versus Medical. In the Cook case, a factor the jury may consider, the court concluded, in determining whether a manufacturer acted reasonably is whether the manufacturer complied with federal requirements. Uh, and those federal requirements are stated in the 510K admissibility. Another case in Arizona District Court, uh, the Baird case, the court recognized that FDA grants 510K clearance only when the device is as safe and effective. It won't grant clearance if it can't pass the safety and effectiveness of a similar predicate device and does not raise additional questions of safety and or effectiveness. The court reasoned, therefore, that even if the manufacturer's compliance with the 510Ks process was not uh, dispositive of the entire case, it nonetheless was relevant to the reasonableness of the manufacturer's conduct and whether the company effectively designed the product at issue. I've attached an appendix that will give you some examples of where the courts permitted 510K evidence to be admitted in the case and some cases where it was excluded. I recommend that if you are in a jurisdiction where it was admitted, then try to tailor your facts to those cases. And if it's in a jurisdiction where the 510K evidence was excluded, you want to make a case for distinguishing your situation and your factual circumstances from those cases. Andy?
Thanks, Ricky. All right, so we're going to move on to my first topic, which is GLP-1s. I think probably everybody on the planet has some idea what these are at this point because they've become such a big thing. But GLP-1s, I'm talking about Ozempic and Wegovy, Zepbound, those types of drugs, the weight loss diabetes drugs. So this first slide here talks about kind of the science behind it. It mimics a natural hormone that the body releases after eating. This medicine releases the GLP-1, which can help lower your insulin level, suppress glucagon release, slow down how fast food leaves the stomach, which we'll see is sort of an issue in an ongoing MDL. It reduces appetite. This started as a type 2 diabetes drug, and people saw how effective it was in people losing weight. So it is probably as well known or more well known now for being a weight loss drug. So our next slide here, there it is. These are some of the major GLP-1s you've probably heard about. So again, you can kind of see the evolution here. We have more type 2 diabetes drugs and weight loss at this point. My understanding, and I work in the claims department. I'm not a doctor, but you're really talking about a dosage level between the diabetes version and the weight loss versus any significant difference in what the drug does or how it's made. So these are the main ones. These are probably the ones you've heard about. So what are the benefits? For sure, and I kind of put these in two different tiers of benefits. So we have the known benefits. This is why the drugs were made, why they were approved. Lowers your blood sugar, it lowers your body weight. We're finding evidence at this point that there's a whole host of other things that we think GLP-1s might do, ranging from lowering blood pressure to improving fatty liver disease to things that you may not naturally think could be the side effect of this weight loss drug, including improving sleep apnea and reducing dementia risks. I would put this middle potential benefits category in. I think we'll get more studies, more evidence that may prove some of these to be, I guess, qualified enough to be a known benefit. And some of them, maybe this is more correlation versus causation. So we'll see. This, like all drugs, is not without side effects. So I've listed some of those in the third bullet point here. The gastroparesis is the number one thing here. That's essentially a slower stomach emptying, or your stomach stops emptying the contents. which has obviously GI problems if that happens to you. So that's sort of the background on GLP-1s. The claims, the legal side that I want to talk to you about, it's essentially two-tiered. One, I'm going to talk to you about the ongoing MDL, and then I'm going to talk to you about compounding pharmacies because those play a role in GLP-1s and where we are in this current environment. So the multi-district litigation, this is pending in the Eastern District of Pennsylvania, so that's Philadelphia. As of the end of September, there were 2,914 cases pending. They're before Judge Karen Marston. Both Judge Marston and Judge Conti, when I talk to you about acetaminophen later on, I think did a good job of taking charge of these MDLs and trying to make a coherent plan here that makes a little bit of sense. So she sent out an initial kind of case management order that said, we're going to look at these three cross-cutting issues that apply across all the different claims. One, gastroparesis diagnostic testing. Two, preemption etiquette warnings. And three, general causation. Because if the defendants prevail on any of these issues, that eliminates at least some of these cases, right? Judge Marston also rejected an attempt to allow the plaintiffs to do a bunch of discovery on marketing, which is, I guess, a fairly typical thing in these types of cases that allows the plaintiff's attorneys to dig around in the aspects of the company's operations that are going to be a little bit more salacious. So she said, no, we're not going to get into that until we've done these cross-cutting issues. She, this fall, reached, or I guess late summer, decisions on a couple of these issues. So the first one I won't get into as much. I guess Ricky talked to you about preemption before. She found that the design defect claims with these GLP-1s were preempted. The plaintiff's attorneys, like they always do, try to put these square pegs into round holes and the very narrow exceptions to preemption, and she rejected those efforts. The part that I think is a little bit more interesting here is the gastric emptying study portion. So gastroparesis, like I said, it's the slowing or the elimination of your stomach, getting rid of its, what's inside your stomach. So both sides say that the plaintiffs have to show that the stomach wasn't emptying in order to show gastroparesis, which is the main injury, and like I said, in these MDL claims. So the plaintiff said, easy, we can do this with what we'll call a differential diagnosis, which is a medical term for scientific method, processes of elimination, whatever you want to call it. The defendant said, well, hold on, that's pretty loosey-goosey, right? We want an objective test to show gastroparesis. And I looked this up, and it's kind of interesting. The way they will show this is they give you a small meal with it's part of nuclear medicine, so it has, I guess, like a radioactive element that they can trace going through your stomach to see if things are moving at all. The court heard this issue on essentially like a motion in limine and expert type motion, and the court agreed with the defendants. So anybody who does not have that more objective study, the nuclear medicine study I mentioned, their cases have been dismissed. So that's a big win for the defendants. And it's also a big win for the strengthened Rule 702 expert standards we've talked to you all about the last year or two. To me, this is another good example of a judge using the gatekeeping function to keep out good evidence and to require some actual proof in these types of cases. So for those cases that were not dismissed, discovery continues. I would expect this is probably another multi-year process until these are resolved in whole, but some good early evidence. The second piece of this that I'm going to talk to you about relates to compounding pharmacies. And some of you may say, what is a compounding pharmacy? And it's a pharmacy, but it's not your brick and mortar Walgreens or CVS. It's a customized pharmacy that's not selling prepackaged medicine. It really has two main purposes, which are discussed on the slide. There's a 503A compounding pharmacy. The way I try to think of this one is, let's say you need a vaccine, and vaccines often have eggs in them, and you're allergic to eggs. Well, the doctor can't give you the vaccine containing eggs, but a compounding pharmacy is going to figure out a different way to make that vaccine for you in a way that you're not going to have an allergic reaction. So they're more person by person type situations where you would use a compounding pharmacy. They're regulated by states, so they're not FDA regulated. The drugs have to be manufactured pursuant to the US pharmacopoeia standards. 503B, those pharmacies are regulated by the FDA, and these drugs are supposed to be manufactured in accordance with the FDA's good manufacturing practices. And I think the easiest way to explain this is they're designed to make drugs where there's a shortage and they need people manufacturing drugs and putting them in the marketplace. So obviously we talked about everybody in the world knows what a GLP-1 is because they've become very popular. I don't have the statistic on the tip of my tongue, but some very large percentage of the US population are already taking GLP-1s. This caused a shortage in the drugs. So the drug was put on the FDA's drug shortage list in 2022, which opened up compounding manufacturers to manufacture the drug under the 503B, which is the drug shortage part that is regulated by the FDA. If GLP-1 compounding is a big business, and it provided cheaper, though as we'll see, less regulated alternatives. So for these companies that are trying to break into this business, this was great. They can make all these drugs, they can make a ton of money. Life was good for them. But we're going to see this sort of ended for them earlier this year when the FDA determined that the key manufacturers of these drugs, so the brand manufacturers, Eli Lilly and Novo Nordisk, were making enough of the GLP-1s to keep up with demand. So the FDA removed the drugs from the drug shortage list in early 2025. So that has three major consequences that I'll talk about. One, no more 503B manufacturing, and that's where the larger batches of these drugs were being made. The FDA's enforcement on the manufacturing, so the prohibition against the 503B manufacturing, started on May 22nd, 2025. I didn't see anything in my research to indicate that the FDA's had a lot of enforcement actions that have at least made a lot of publicity. People like Ricky directly counseling these companies may have a different story. I would not be surprised if we start hearing about some 503B type issues in the enforcement because that industry did not go quietly out of the space. There's a group, get their name for you all real quick, that's basically a trade association that's filed lawsuits that have tried to overturn the FDA's decision to take the drugs off the list. And that is called the Outsourcing Facilities Association. And so they've been a player in some of these cases. And I wouldn't be surprised if this becomes another avenue for them to try to turn around this prohibition against 503B. So if you can only do a 503B if you can't do a 503B manufacturing rather, then only the 503A compounding is available. It's kind of stretches logic to argue that you can mass produce these types of drugs and have it fall under the 503. That's we're taking a drug and changing it into what you need because of allergies or things like that. So mass producing this and arguing that this somehow is 503A, I think is a stretch and causes problems for these companies that were doing the manufacturing of these GLP-1s. And then the third element that makes life difficult in this space is brand name manufacturers are pursuing compounders who are still mass producing these drugs. There was a decision from September. Eli Lilly and Company brought a lawsuit against an entity called Adonis Health. This was on the motion to dismiss, so this case is still going on. But the court found that there was enough for Eli Lilly to say that it was false for the compounder to argue that the GLP-1s were personalized when they were being mass produced, and the case was proceeded. There's other similar lawsuits. Again, I mentioned the Outsourcing Facilities Association. they have been largely unsuccessful in having courts find that removing the drug from the drug shortage list was improper. Um, so I think the world has probably changed. Other larger manufacturers are getting closer to putting competitors to Eli Lilly and Novo Nordisk on the market. So I think we're going to see this market flooded a little bit in the coming years, even if this compounding segment is essentially in its last stages here for the time being anyway. So the other thing I want to tell you about with this, the FDA, this is again, I think about September or so, they issued a green list to warn Americans about some of the active pharmaceutical ingredients. So the main chemicals and ingredients being used in these drugs. There are a lot coming in from foreign sources that the US is a little concerned about, essentially the safety of these drugs. So this is a little couple snippets from that blurb. And that is actually a link to the list of the green list, which is those drugs that are the US has inspected and they've investigated and found that these are going to be safe. So that's, I guess, you can't click here when you're looking at the screen, but that's a link to that website. So that's GLP-1s. If that wasn't exciting enough for you, now I'm going to talk to you about Loper Bright, which I talked to you all about last year. And the Loper Bright, and I'll get into this in a second, is essentially a US Supreme Court case that talks about how courts should interpret ambiguous statutes. So, statutes rather. So I have here out with the old. So Chevron, this was a US Supreme Court case in the 1980s. The US Supreme Court said, look, if there's federal legislation and you think it's ambiguous, you should defer to how the federal agency has interpreted that legislation if it's ambiguous or it left a gap. The idea here was that the federal agencies should have the ability to advance their regulatory priorities. The US Supreme Court in 2024 said, yeah, we're going to overturn Chevron. We don't like that. Courts must exercise independent judgment with deciding if an agency has acted within its statutory authority. And there's no longer a deference to agency interpretation if the law is ambiguous. So I had several slides here last year saying this can really complicate things, and especially in the FDA space, life sciences, where you're dealing with very technical and scientific issues, and how effective is it going to be to have judges who are people like me who largely don't have a good solid science background trying to figure out technical issues. And there were a couple snippets from Loper Bright that I quoted where the court was sort of acknowledging that in the opinion itself. So how has it been? We're 1 year later. It's been a mixed bag. The main issue that is kind of out there is how do we apply Loper Bright? So many things are political these days or on a political spectrum. So those courts that you might expect to more fully embrace Loper Bright, which was decided by the Supreme Court with maybe a little bit more of a conservative bent, have more fully embraced Loper Bright than maybe some of the other federal appeals courts that were maybe not a big fan of overturning Chevron. The main way that these appellate courts and trial courts have been trying to resolve these issues is going back in history and saying, well, if we can't rely on Chevron anymore, we're going to rely on Skidmore, which is a 1944 US Supreme Court case, which is the one that Chevron overturned. So we've just, I guess, moved back in the Supreme Court history. Skidmore is technically not deference, but it allows courts to find the agency interpretations to be helpful or persuasive. The decision talks about respect and looks at the thoroughness of the conclusion and whether that's kind of been consistently the agency's position. So explicitly or implicitly, a lot of these courts are taking that analysis to, I think, do something I would equate to be almost like a Chevron light of we still need some help from the agencies to decide some of these issues. Like I said, there's the other end of the spectrum where they're just completely ignoring the agency and reaching their own interpretations. I would expect this is going to make its way back to the U.S. Supreme Court at some point. Whenever you get a bunch of U.S. Circuit courts reaching opposite conclusions on the same issue, that's often a recipe for the U.S. Supreme Court taking the case or taking this issue back up. So, what's going on in the drug and device world? I'm happy to report nothing terribly bad that I found. This was one case I wanted to talk to you about. So, Suboxone's getting into the opioid antagonist. The plaintiff's attorneys argued that Loper Bright eliminated preemption. That's wishful thinking, and I think really 180 degrees from what Ricky was telling you guys in the last section. And I'm happy to report that the court uh, pretty quickly disposed of that argument and said Loper Bright says little, if anything, about preemption. Instead, Loper Bright involves questions of deference to agency interpretations of ambiguous statutes, and preemption involves determining the intent of Congress, not an agency. So that is, I think, the legal way of politely saying, nice try. This doesn't make any sense. So that was, I guess, the most relevant application or attempted application of Loper Bright that I found in our space, the life science space in the last year. The last piece I'll talk to you about is Loper Bright being applied in the state courts. So this was my play on, what's good for the goose is good for the gander. I don't know how well it's going to play off there. And I did learn, I had to look this up because I was curious, a gander is a male goose. So there's your factoid today, if you didn't know what a gander was. So for the lawyers on the call, this first bullet point will be fairly obvious. Loper Bright applies to federal law, not state law. So that means state courts do not have to follow Loper Bright. 34 states give some level of deference to state agencies, but 2025 saw a shift away from that deference. So there's about 5 or 6 states I listed there that eliminated or limited their Loper Bright, sorry, not Loper Bright, but their deference to state agencies. The one outlier in this is Hawaii, that said, in Hawaii, we defer to those agencies with the, I'm just going to say, knowledge, wisdom on particular subject matters to get complex issues right. So again, this is not an absolute trend, but some of the states that you may expect to have more fully embraced Loper Bright have done so. And so this will become an issue both with the federal courts and federal law, as well as in a lot of states. So with that, I'm going to turn it back over to Ricky, who is going to talk to you about recent developments with LDTs.
Thank you, Andy. In addressing laboratory developed tests, it's appropriate to discuss some of the regulatory background in terms of how we got here and where here is. In 1988, CLIA, the Clinical Laboratory Improvement Amendments, established a regulatory framework for laboratory developed tests. As services, laboratory developed tests are regulated by CMS, the Centers for Medicaid and Medicare Services. As you will see, that's a big fight in terms of who should appropriately regulate laboratory developed tests. Is it CMS and CLIA as services, or is it the FDA as devices? FDA announced its intent to regulate laboratory developed tests as medical devices on May 6, 2024, in what's called its 2024 final rule. However, there was a lot of pushback with respect to the FDA indicating that it would regulate laboratory developed tests. Many thought that the FDA was overreaching. Some thought it was appropriate. And so as I've witnessed and experienced this regulatory and jurisdictional fight, I'm sort of in the middle, and I think the FDA was right, and I think the Texas District Court was right. But on May 31st, 25, a Texas federal court ruled that laboratory developed tests are services and do not constitute medical devices subject to FDA regulations. If they're not medical devices, the FDA cannot and should not regulate them. Next two slides, Andy. Skip that one. So many have viewed the FDA as not having authority to regulate the laboratory developed tests because they're services. In announcing its 2024 final rule uh, and the intention to treat laboratory developed tests as devices, the clinical laboratory services industry saw the FDA as essentially conflating two concepts. They are essentially, one, conflating test products for commercial distribution, test products like COVID-19 tests, which are reasonably subject to FDA regulation as devices, but conflating them with physical tools that laboratory professionals use to deliver a service. And physical tools used to deliver a service are not subject to FDA regulation because they constitute services, not devices. Well, let's take a look at a cautionary tale in this fight over who should regulate, who should have jurisdiction, and why. Many of you may remember Elizabeth Holmes, the chief executive officer of Theranos. You may recall that she uh, had a company that was valued at over $1 billion. She got all kinds of stars and celebrities investing. She was on top of the world until a conviction uh, on fraud and conspiracy for knowingly making false claims regarding the accuracy and reliability of the blood test. Now, remember, uh, CLIA regulates uh, certifications, how the labs operate. They don't regulate the resulting product. FDA would effectively regulate the resulting product, essentially a device. But when you're focusing on the services, that's not subject to FDA regulation. And in exercising its ability to identify fraud, the FDA uh, perceived the Theranos case as an example of the need for it to get involved and regulate these tests. However, the clinical laboratory services industry used the very same Theranos case as an example of why the FDA should not be regulating laboratory developed tests and how inept the FDA was in having approved the initial laboratory developed tests for Theranos against the backdrop of all the fraud and conspiracy problems. So the FDA saw Theranos as an example of its involvement and how it did the right thing in stepping in and identifying the problem and notifying the Center for Medicaid and Medicaid Services. And the clinical laboratory services industry saw that same case as an example of how inept the FDA was and how inappropriate it would be for them to get involved in regulating laboratory developed tests. Next slide, Andy. Next two slides. Next slide after that. So after a federal court vacated the final rule, there was much discussion about overlapping or distinct roles of CLIA and the FDA. As I've mentioned, and CLIA's role is and has always been to regulate facilities performing healthcare services. The FDA's role is to regulate products like medical devices, not services. The key question for the federal court in determining who gets to regulate laboratory developed tests, whether it's FDA or CLIA, is whether the methodology or process for conducting a laboratory developed test is a service performed by a lab technician or a product created by a lab technician. This federal court found that laboratory developed tests uh, were not like drugs and not like devices that are manufactured, packaged, and released into commerce, but instead was a service that generates information from test results and passes along that information to an ordering physician. And so it's very nuanced in determining the extent to which a laboratory developed test is like a COVID test, or it's essentially someone gathering information from test results, passing that information along to physicians. It's very nuanced in terms of making that fine line distinction, but this federal court found that the distinction favored uh, the clinical laboratory services industry, that they were performing services indeed and not a device, and that the FDA overstepped its jurisdiction in attempting to regulate laboratory developed tests as devices. And therefore, the FDA was required to retreat. On September 19, 2025, the FDA retreated from its exercise of jurisdiction over laboratory developed tests and issued a final rule reverting to the text of the regulation before its final rule. Next slide. So what impact will the federal court ruling on CLIA's authority over LDTs and the FDA's retreat have on the clinical laboratory industry? Some things will change and some things will remain the same. Laboratories and their methodologies are currently subject to CLIA regulations by CMS. That will not change. Tangible equipment like COVID tests providing diagnostic information will still be treated as devices subject to FDA regulations. And despite the legal victory for laboratory developed test industry, this battle is likely to shift back to Congress, largely because many of the concerns that the FDA had in deciding it needed to and that it was essential to regulate laboratory developed tests, those have not been resolved by reverting back to CLIA's oversight. Those concerns, as I will discuss in a second, remain. There are certain aspects of the clinical testing industry that will not be impacted by the court's invalidation of the FDA's final rule. Uh, the FDA will continue to require the following types of tests to meet applicable FDA requirements: direct-to-consumer testing, tests intended for donor screening for blood or human cells and tissues, and cellular and tissue-based products, tests intended for emergency use associated with cyber devices, and tests manufactured or used outside of a clinical laboratory. Next slide. The regulatory landscape is likely to look a bit different in the future. I believe Congress will be heard from very soon on the question of laboratory developed tests oversight, because the Texas federal court decision did not eliminate or mitigate many of the concerns that the FDA had for attempting to impose its jurisdictional authority to begin with. When the term laboratory developed tests was first coined, laboratory developed tests were of lower concern to the FDA. They were not very sophisticated. They were limited in scope. Advancements in technology and increased automation has increased the need for more regulatory scrutiny over laboratory developed tests. Remember, CLIA focuses on services. They don't focus on products. And with the complexity of laboratory developed tests, we are getting more into the mechanics of the actual products. And that makes sense for FDA to regulate and to step back in. With increased technology, cyber security incidents and threats are likely to soon follow. I mentioned cyber threats and cyber devices. Section 542B of the Food, Drug, and Cosmetics Act addresses risk associated with cyber devices. And any product that meets the definition of a cyber device is going to be subject to FDA regulations as part of the pre-market submission process and as part of the post-market management and monitoring process. So where we're headed from a regulatory standpoint, and what are the headwinds reveal? Well, entities manufacturing laboratory developed tests should take care to meet FDA compliance requirements in the broader context. And that broader context relates to cybersecurity, research use only, medical device reporting, quality system regulation. I noticed that there was a question regarding research use only. And one of the things that I would point out is that a product inappropriately labeled as research use only when it is indeed being sold or used in a non-research capacity or as in a diagnostic setting will be deemed by the FDA as misbranded and adulterated. And so if you're claiming research use only, you need to make sure that the product is indeed being used as it is labeled. Andy?
Thank you, Ricky. All right, so our last substantive topic here is going to be autism and acetaminophen, or otherwise known as Tylenol, still an issue. So again, to give you a little bit of background here, in 2022, an MDL was formed in the Southern District of New York. That's Manhattan. There's about 500 cases. The allegation was that acetaminophen caused autism and ADHD. Again, sort of similar to the GLP-1 MDL we talked about. The judge and Judge Cote said, why don't we first determine if acetaminophen is capable of causing autism or ADHD? Because if the answer is no, then we don't need to do the rest of this discovery and take these depositions and et cetera, et cetera. Well, here's kind of the timeline of how the case progressed in the trial court. In December 2023, Judge Cote excluded all 5 of the plaintiff's general causation experts and essentially said there's no generally accepted scientific conclusion that in utero exposure to acetaminophen causes either autism spectrum disorder or ADHD. Time passes. There's a second motion to strike an epidemiologist who was disclosed as an expert in some later filed ADHD lawsuits. Judge Cote says, again, this doesn't meet the standards of Rule 702. I'm going to exclude this expert. In the following month, she said, okay, well, I've excluded all your experts. How are you going to prove your case? And long and the short of it is that the case was dismissed. So you would think that's the end of our story. Everybody's happy. But in the words of Lee Corso, for you college football fans, you may recognize this, not so fast, my friends. So September of this year, the White House, the FDA changes course on the acetaminophen autism link. And in bold there, you see the quote from President Trump that says, so taking Tylenol is not good. I'll say it. It's not good. For this reason, they are strongly recommending that women limit Tylenol use during pregnancy unless medically necessary. At the press conference, they said that they can change the label to provide a warning about the drug being associated with a higher risk of autism, and that a nationwide Dear Doctor letter would be circulated on the same issue. Texas immediately jumps into this fray. In October, the AG of Texas filed a The lawsuit against Johnson & Johnson and Kenvue, who is the current owner of Tylenol, and I believe Kimberly Clark is going to be the new owner. So it's the Tylenol has sort of changed ownership here a few times recently. And the allegation in this lawsuit is that J&J and Kenvue hid the risks of autism and engaged in deceptive marketing in Texas. So there's some quotes here. Kenvue says, "We are deeply concerned by the perpetuation of misinformation on the safety of acetaminophen and the potential impact that could have on the health of American women and children." The uh, American Association of OBGYNs, essentially, they have not changed course. They still believe the drug is safe. In this Texas lawsuit, this was just about last month, I think, made a couple recent decisions. One, the judge denied Texas's request for a temporary restraining order prohibiting Kenvue from marketing it as a safe drug for pregnant women in Texas. This was especially interesting to me. Texas also had asked the court to prevent Kenvue from issuing a dividend to its investors, arguing essentially that that would be a fraudulent transfer, that Kenvue would be getting rid of its assets, I guess, before Texas's big win in this lawsuit. Dismissed J&J. The lawsuit remains pending. Again, Texas is undeterred in this. The same day that these orders came down in the trial court on this previous case, the AG announced investigations of these products and drugs that are listed on this slide, two of which they had already investigated, J&J, with respect to the safety and efficacy of these products. So J&J filed a suit saying, we're the parent company of the companies that are actually making these drugs, and there's case law in Texas that says we don't have to produce these massive tranches of documents. That is not, as far as I know, been decided yet. But Texas is clearly going after J&J and J&J in particular on both acetaminophen, and it seems like these kind of other ancillary issues, given that the trial court kicked J&J out of the Tylenol case pretty quickly. So the other not so great thing on this front is there's an appeal to the Second Circuit from the MDL, Judge Cote's rulings on the experts. The oral argument here was held in November, rather. You can see two of the three judges had pretty vocal criticisms of Judge Cote's decision. There's no ruling on this yet, and until you see the ruling, you never know exactly how these appeals will land. But these are pretty directly adverse statements about what Judge Cote did. So I think the expectation may be that the MDL will come back when the Second Circuit reverses Judge Cote's rulings. This is a bummer for many reasons, in part because we've talked about the Rule 702 amendments with you all before, and that this is supposed to give more teeth to the federal court to keep out bad science and to have a higher standard here. And if the trial courts do this and the Second Circuit or other appellate courts tell them, well, no, these things should go to a jury, you shouldn't have made these types of hard decisions, I can only see that as being a positive for the plaintiff's bar in the future. The last bit here I'll mention, there is an MDL in San Francisco in the Northern District of California alleging that toxic heavy metals in baby food cause autism. There's 600 baby food types allegedly impacted. I list some of them in the slide. This week, actually, so I guess we're right in the middle of it, there's a 5-day, essentially like science day hearing going on in that case to try to have the judge assess whether there's enough credible evidence of the link between heavy metals and autism to allow this lawsuit, this MDL, to go forward. And in doing my research, I came across a couple of plaintiffs' firms that on their website say, hey, don't worry about this Tylenol thing. We agree with the science there, but this is your safer alternative. We think the evidence here is stronger on the heavy metals in the baby food. So maybe that's one that proliferates a little bit if the plaintiff's attorneys get past this science day hearing that they're dealing with right now. So the last thing this is our last slide. This has our contact information. We usually give you a what are we going to be talking to you about next year prediction, and I'll do this pretty quickly because we're running close on time. I think we're going to be talking about whatever the next thing is for the MAHA movement. I think that clearly impacts what we're talking about with the acetaminophen. I suspect that there will be similar issues coming up in the next year that will kind of put this further exacerbate this tension between the industry and traditional science and what's coming out of the FDA these days. So I'm not smart enough to predict exactly what that'll be for you, but I expect we'll be talking about similar types of issues next year. So Ricky, did you have anything you want to elaborate on? You're muted.
I think we can expect to evaluate how Congress could intervene in codifying longstanding regulations with respect to the definition of a drug versus a device after the Genesis decision. And the FDA is essentially in trouble because if it decides not to sue and leaves thing as is, or if it decides not to change the designation of drugs to devices, there are going to be some lawsuits associated with that. And if it does go ahead based on the Genesis decision, start reclassifying hundreds or thousands of drugs into the device category, there are going to be lawsuits from the drug industry based on that. So you can expect that Congress is going to have something to say about the regulation and recharacterization of some drugs to devices, certainly in the contrasting mechanism industry. That's one of the things, and maybe from a drug standpoint, FDA proposing sweeping changes to accelerate biosimilar development to increase the speed, almost cut in half the research and development associated with that, and maybe bring the cost down significantly. So those are the two things that I see. What is Congress going to do with respect to the FDA reclassifying many drugs as devices, and what is going to happen with respect to biosimilars entering the market more quickly, because obviously that's going to mean some potential patent due diligence and possibly patent lawsuits by so many biosimilars hitting the market so fast.
Great. I think, Ricky, maybe we have time for both of us to do one question. I know there's been a couple that have come in, so I don't know if there's one you want to answer, and I'll do one, and we can turn it over to Kate.
Sure. If you want to take a couple of minutes for questions, we're just coming up on the hour now.
Yes. How good are compounding pharmacies at making the drug as consistent as the drug manufacturer? Well, that question creates a couple of problems. One, the more consistent it is with the drug manufacturer's product, the more likely it is to get sued for patent infringement. That's one thing, and the extent to which it is dissimilar and not consistent with the drug manufacturer's product, it simply needs to say that. It can't represent in any of its marketing or promotional material or labeling or website that it is something that it isn't. Whatever your product is, say that and not more, because once you get into saying that it's more, then you're subject to FDA violation for misbranding, mislabeling, and promoting an adulterated product. So you're caught in a catch-22. If it's similar, you have patent risk, patent infringement risk, and if it's dissimilar, you have the risk of promoting a drug that doesn't do what it says it does, and it doesn't have the intended impact.
I would agree with that, Ricky. I think the FDA has some concerns about this. That's kind of one of the main reasons for the green list to make sure um, people making APIs for these types of drugs that there's some belief that they're safe and effective and should be used. The question I got was fairly similar. How do pharma companies prepare for GLP-1's unintended consequences from this unbridled usage? I think the answer to that question is probably in what we talked about. You mentioned there's IP issues. There have been lawsuits by Eli Lilly and Novo challenging some of the representations by the compounders and um, challenging those issues. And I think you had mentioned to me, Ricky, when we were talking before the presentation, that even the process of making these drugs, there's attempts to try to enforce intellectual property rights on that. So I think it's a tricky world, and I think that the brand manufacturers are doing their best to kind of protect their rights while they can and um, protect their market share.
No, exactly. And uh, it's typical of the manufacturing industry. They spend millions of dollars to get something to the market, and then compounding pharmacies come in without spending any of that money, and they sell it for pennies. They sell the same product or a similar product for pennies on the dollar. So,
Yeah. Well, again, Ricky, thank you so much for speaking with me. Kate, I think that's what we have, and I'll turn it back to you.
Well, thank you both so much. We really appreciate your time today. This has been quite a year in life sciences, so we know our audience will really appreciate your expertise and your insight.
thank you, Kate, and thank you, everyone. It's been a pleasure, Andy. Thank you.